Thank you very much. This reminds me of being back with Jim Perry, and I started out like a lot of all of you did. I'm straight out of law school with a staff attorney with PERC on OPS. Tom Brooks, I don't know if any of you have heard on him. We both ended up eventually general counsel and then on the commission and so forth. So you're bringing back old memories, and I'm very glad I'm semi-retired and don't have to do the job you have to do every day and all day, because it's a difficult job. If you're dealing with employees and supervisors and higher level managers, and you've got an employee with a problem, it's difficult from the employee's perspective and from your perspective. And I know this, having represented both sides and having been a neutral, and now seeing for the past 25 years or so, people come before me through arbitration. I think by now I feel like I've kind of seen it all. Situations you could not believe employees would become involved in, and situations in which you could not believe the manager would deal with the employee in that way. So I've seen the gamut of them. I think probably on the whole, management, if you're asking for a percentage, usually prevails. I mean, actually, they kind of should if you have the chance to get your case ready and try to settle cases that should settle. That's the way it probably should be, but I don't keep a record, so I don't really know for sure. But today I'm going to just be limited to the concept of just cause. Now, in the presentations you've had so far from Jim Perry and from Greg, you've had a lot of rules to follow, and this is the way it has to be, and that is correct. That is the way it has to be. Arbitration really is very different. And it's intended to be very different. It's intended to be an informal process where, in the first place, people aren't scared out of their wits, and there's not all these rules that you have to follow. And on the other hand, it makes the remedy be kind of a free-form remedy that doesn't have a lot of constraints to it, other than if there might be some limitation by statute, as I've seen in the presentations and heard you know, in arbitrations. So to start with, let's try to figure out when you go to an arbitration, how does it start? First place, how many have done arbitrations? A few of you. How many have done just cause arbitrations? Okay, well, if you don't have a lot of experience doing them, hopefully you can pick up a little bit of information here. I can't tell you exactly what it is, or you could give me any set of facts ahead of time, and I can't tell you how it's going to end up, because it depends on what's presented at the hearing. And it's amazing how testimony just doesn't come out the way you want. I know it's happened to me, and I see it happen before me with cases. But I have to decide the case based on what I do here. I always start with trying to be sure I have authority to decide the case, because I've been involved at least in one incident where it was a 3-day case, and it was before a big institution in the state, and everybody decided on me as the arbitrator. The employee, no problem with it. We go through the whole arbitration. It gets done. The employee decides they don't like the outcome, and I wouldn't either, but it was well deserved. But they decided to take it to challenge it. And they went, I'm not kidding you, all the way to the US Supreme Court. You can imagine the type of employee this was, a very litigious and very knowledgeable employee of how to work the system. And even one of the acts they used was the, the Federal Arbitration Act. And so I learned from that case, if I didn't already know before, to be very careful about, before I ever accept a case, even though the parties are before me, to know that I have jurisdiction to hear it. And also to figure out, what do I have jurisdiction to order? And do the parties agree on the remedy? What are my constraints? And there usually are some, and I need to find them out up front. Okay, so the first thing I always ask the parties is, what have you agreed upon are the provisions in the collective bargaining agreement that give me authority to hear this case? And usually they look to the definition of a grievance, and it's usually a just cause for dismissal or whatever, just cause for something. And here is the provision in the contract. Okay, that's fine. And then where are the limitations of my authority? And I think Mr. Perry and Mr. Morton already showed you some of them, and we'll see some of them a little later on in some of the provisions. But the most kind of unusual one to me for the state is there are 7 contracts that Jim gave me that I've seen some of them already before in arbitration hearings that talk about just cause provisions and all the various limitations. And there are several. One of them, it says, I guess the idea of it, because this came up in a case in Miami a few years ago, is if there's just cause, it has to be just cause for whatever the remedy is. So in other words, the arbitrator cannot mitigate, cannot reduce the penalty. That's very, very unusual, because part of one of the basic concepts of just cause is that there has been a violation of something or some very inappropriate behavior, and whatever the remedy that was penalizes this action, this discipline, is supposed to be reasonably related to the remedy. Now, the employer doesn't have to give the most appropriate remedy, but it has to be an appropriate remedy. And management has a lot of discretion in what that can be. But for example, if the employer disciplines someone by discharging them, and there's a very minor violation, I can't hold then that there's a reasonable relationship between the misconduct and the remedy. So with the state's provision, in the way, if there was dismissal for that act, I would just say that I would not uphold I would affirm the grievance and dismiss the action that the state took. Not dismiss it, but return it and just say the grievance was granted. In other words, that provision, and I think it might be one of the AFSCME contracts, I'm not sure. It just doesn't say just cause, it limits it that way. And that was a very perplexing thing the first time I saw that provision. But that to me means, it may be something different to other arbitrators, but that means if the state agency is discharging someone for a certain offense, there has to be a reasonable relationship between what the employee did, assuming it's proved, and what the offense is. And if there isn't, then my only recourse is just to grant the grievance, because there wasn't that reasonable relationship. Okay. The burden of proof, and the other 2 speakers have mentioned this also. Normally, in just cause cases, it's on the employer, but not always. Normally, it's a discipline case, suspension, dismissal, a transfer maybe, a warning, a written warning, something like that. Depends on whatever the contract says. Okay. But non-disciplinary cases, it's usually on the union or the grievant. And a non-disciplinary case can be like a transfer. Oftentimes, a transfer, there's a valid basis for it. It's not being used to discipline at all, although the employee probably sees it differently. But I usually, in those cases, would always put the burden on the union. And of course, that's important in planning your arbitration, who goes first. That's about the only basic difference it is. If the burden's on the employer, you go first. Otherwise, the union, they go first. Now, in arbitrations, when I come into the case, I often don't even know what the case is about, other than it's a just cause case. And a lot of the cases I have are just cause cases. I certainly have no idea who the witnesses are, unless some of the formal cases through American Arbitration Association, they do make the parties list all the grievances, all the witnesses, to be sure I don't know any of them. Because if I ever know a witness, I would have to reveal that to the parties, and probably would not get assigned that case if it comes through the American Arbitration Association. But normally in grievances between school boards or counties or cities or state agencies, I don't know who the witnesses are going to be until they actually appear. So whether you have the burden of proof or not is important, because if the union thinks that the employer is going to go first, then all of a sudden they have to have all their witnesses lined up. That would be a rather shocking thing. So I'm pretty sure the unions always assume, as they should, that if the case doesn't involve discipline, they have the burden of proof. Work performance cases are different than appraisal cases. In some cases, employees can appeal what their evaluation is. That's kind of like an appraisal case. That would be the union, in that case, if they would come before me, they would probably have the burden of proof. Whereas in a dismissal case for work performance reasons, the employer would have the burden. Okay. Now, the standard of proof that is used, it's generally 90% of the time a preponderance of the evidence, which means it's more likely that this misconduct occurred than not. It's a fairly easy burden to prove in legal circles because it's not clear and convincing. It's not proof beyond a reasonable doubt in criminal cases. So it's a fairly easy 51%, 50% burden to prove. Hopefully, if you have all your facts lined up, that shouldn't be that difficult a burden to meet if everything goes at the arbitration as you'd hoped and as you'd planned. All right. But in cases, and for the state cases, Jim Perry told me that in the contracts, most of them have that this is what the standard is. But generally speaking, in arbitration circles, or any arbitrators that I know, if someone is accused of a crime like theft or a stigmatizing misconduct like sexual harassment, the arbitrator is going to apply what we call the clear and convincing standard, which most of you are attorneys here, correct? I think, or HR type people that have or probably know as much as attorneys about labor and employment law. The clear and convincing standard would be used. Now, what does this mean in reality? Well, when the case before an arbitrator involves a discharge, that is considered to be like the death penalty for employees, right? I mean, it can damage someone's career forever if they're discharged. So an arbitrator, like I would hope management, takes it extremely seriously. Right, and the preponderance of the evidence is the standard for most discharge cases, unless it's something like criminal conduct alleged. But I think arbitrators, and myself included, would really be very careful that the evidence that we have clearly shows that this misconduct had occurred. Now, what do I mean by that? That's very esoteric, right? What a good example of that is I may have witnesses that say totally different things. So I have to resolve that conflict in testimony. Now, I remember when I first became a lawyer, I thought, well, you can just look at people, and that's one of the reasons for live hearing, but really, a lot of people are very good liars. You cannot just look at people that are before you and figure out whether they're telling the truth or not. So I know as lawyers you've been trained how to do it. One of the things that's most helpful to me, and that's the bottom of this slide, is to look for inconsistent statements or accusations. In other words, if your management, have you accused this person first of one thing and then of another thing, and are you not consistent with what the accusation is? When it gets right down to it, you have 12 things. It started out with one thing. So you look at things like that. For the employee, a lot of times their justification will change. And when that type of thing happens, it makes me wonder about the credibility of that particular piece of information in any event. But this is very difficult. Credibility is a very difficult issue to resolve. And I've spent many hours worrying about whether I was really bamboozled by the testimony of someone that was a really good liar. And I would hate to think that has happened, but I would not absolutely count it out. I don't know what happens after the arbitration cases are over. And I don't know, I just don't know. So I wonder if I've been correct on things, but I'm always trying so hard to see what is really going on in this case, and if the person accused of misconduct really did do it or is very likely to have done it. And hearsay, I know Greg went over that. Hearsay is admissible in arbitration. You can rely on it. My lawyer background makes it very difficult for me to do that. So I usually allow it in, but make it very clear that I'm probably going to give it no weight. Now, I have had some issues where, of course, hearsay has a lot of exceptions. And for state agencies, a lot of things that are written and records and governmental records you can use, which will be an exception to the hearsay rule. On the other hand, employees, of course, have any managerial statement that would be adverse to the situation that they can get into, that is hearsay. And those are the two things that happen most often. But I've had situations like a teacher, kids accusing him of sexual acts or, touching and so forth, but nobody wanting to have their kids testify. And they had they first had the principal and the assistant principal investigator, had these kids, of course, junior high kids. And junior high girls and male teachers, I mean, it's not unusual that there's a problem there if the kids start not doing well in junior high. I don't know if you've ever run into this, but I have run into it representing people, so I know what I'm talking about, and I've had it before me. And the kids, I can see what they say in their statements initially. I can see what they see in their statements when the official investigator comes in, like a month or 2 months later. And you wonder if it's really the truth against this person, this very rigid teacher that everything has to be the right way and so forth. So in that kind of a situation, I am not inclined to rely on the hearsay. So if the employer is going to bring a case like that, you've got cases where you've got prisoners. I've had state cases where prisoners have said one thing, this supporting the employer, supporting management, and unless the person appears before you, you do wonder about the veracity of what they have said in a written statement when they have somebody with them that they know what the person wants them to say. So that is a situation where if you've got obvious testimony that you are going to need to rely on, that's hearsay, that's a problem. And you may be able to work something out with the attorney for the other side or the representative for the other side, because they may not want them there either, or they may have a similar situation. So, but that's a case that you need to consider. Hearsay is admissible, but arbitrators treat it very differently, and I would say most of the time they are not going to give it much weight, but they will allow it into the record anyway. Okay, now as far as how just cause is defined, I don't think this has happened lately really, but in the past, some employers have come in and tried to argue that because it doesn't say just cause in quotes, it's not a just cause provision. That is not usually true. It is probably almost never true unless during collective bargaining negotiations, and you're doing a contract interpretation case, someone can show that that is exactly what the parties agreed to. They meant just cause those words to mean something else, or you don't know. But generally, the language will be for cause, proper cause, just cause, or just cause. Any of them mean the same, they contain the same concept. They are intended to try to express the same concept. And what is that concept? There's no set definition. I defy you to find a provision or a definition of just cause that everybody accepts. It just doesn't exist. I hate to say this, but it's kind of you know it when you see it, Or it's more likely you know what it isn't when you see it. After you hear everything. I can't tell you the number of times I've heard one side, we've taken a lunch break, or we go to the next day, and I think, this guy's out. This is very clear. And then some of the other information comes in, and you're going like, on the ride home, I'm not so sure about that. I also realize that when cases get to arbitration or that stage, a lot of them are close cases anyway. They're either close cases or one side or the other is intransigent. The employee wants this. I can remember one night, one of the early cases I had. This one was when I was actually a general counsel for Florida Education Association for a few years. And I had this teacher, this older guy, and he really needed to be retired, but he wouldn't give up. And I finally got him in late night negotiations what he said he wanted, and he waffled. And I remember reading him the Riot Act and saying, I wrote 1, 2, 3, 4, 5, I got you everything, take it, and not knowing the next morning whether he would. So I know I see cases like that. When the people are there, they're doing the best they can, so they don't get a duty of fair rep charge or something like that. And it's usually pretty obvious. And then for management, I know you have to represent people. I know you're not all the highest people in your agency, and you're having to represent people that just will not settle. I remember telling a partner, a high-end partner in my law firm once. I worked for a law firm for 18 years. And it was a case, I did all that labor stuff for him, which wasn't much at the time, but and I said, you know, this is a violation. It was nothing with employees. It was about access for disabled people. They have to have this much space. We're going to pay fees one way or the other. How long do we want to wait for fees? So I've seen it at both ends, that they just won't settle. But most of the time, the cases are fairly close. Okay, now what kinds of misconduct is it? I always have to try to figure that out, which you've already got it figured out before you've come, but sometimes it's not that apparent. Sometimes there's just a collective bargaining provision that says, do not do this certain thing, and they did it, and you know, that's it. Sometimes it's not anywhere because, you know, you don't have, like, this is not a real example, but do not murder, do not punch people, do not, you know, it's just obvious that it's unacceptable conduct, but that particular provision isn't there. So sometimes it's a violation of a state or a federal law. I've had, not for just cause like sexual harassment, I mean, you name it. All the kinds of discrimination things. I think I've had them all, except I haven't. Yeah, I even had a same-sex thing one time. 2 gay employees, I had that too. So anything that could be covered under state and or federal law can usually be arbitrated and sometimes is. Okay. So, but I have to know what it is, because sometimes, like if it's federal law and it involves attorney's fees, that's something to be considered, but that's very unusual. Usually arbitration cases don't have attorney's fees. The norm is no attorney's fees. It would have to be unusual that they did. Okay. And then if it's an agency rule, and I know I heard Greg say this too, be sure and make it very clear that the arbitrator understands what the rule is. Bring the rule there so the arbitrator can see what rule the employee is alleged to have violated. Okay, the levels of misconduct. There are a lot of levels of misconduct, but there are 2 that are very important. One is what's considered, you know, not very serious. What they did was wrong, like maybe being late a whole lot of times, or then other things are very serious. An example that I could tell you is that stands out in my mind because I was so surprised was a school bus driver, a lady who drove little kids. And it was the end of the day, and these kids were like kindergarten around that, and she got them all out of the bus, she thought her bus was empty, she'd made all the stops, but one kid was asleep in the back, one little kid. And so she parked the bus at the end of the day, and it was near some construction site, and I don't know how many hours later the kid wandered out, and a construction worker found the kid. Now, I was pretty appalled at that. I mean, that was very, very serious. The kid could have been killed there. He could have been, or she could have been accosted by somebody. I mean, that's just a complete breach of trust on the part of the employee. And that's an example of something to me, very serious. And there are other implications of it being very serious other than winning your arbitration case. But that is, and I think Greg mentioned this before, that's normally something you can fire someone for without even giving any kind of a pre-hearing consideration because of the seriousness of it. And so that's an obvious one. Another one is breach of trust when you're working, especially, well, cops. We had cases recently with that, where someone, a pretty long-term employee on vacation, and of course, the response to both of these, the lady bus driver and this one too, is that they were under extreme duress, stress, illness, whatever at the time. Which, given that being true, it's still serious enough to support dismissal. Employees, I don't ever like to talk about cases I had that so they could ever be identified. But when they're involved with like cohabitating with a student or someone under their direct, and that person is also disabled, like with drug and alcohol use and so forth, and you're a facilitator to it. In other words, that kind of a relationship. Now, there's no rule generally that you point to against cohabitating, but because of the cohabitation and what happened and all of that person relapsing, that the higher-ups had no faith in that employee that cohabitated with the graduate student. So, you know, that complete breach of trust, I think, is something that any employer, including any public employer, has an absolute right to rely on. And if employees breach that trust, that's a very serious matter. I had this was in the law enforcement case recently with a city in Florida, and the attorney submitted an 84-page brief on this subject. And I don't usually encourage lengthy briefs. In fact, 10 pages is fine with me, 20 like max. And some discharge cases, some of sometimes they don't file any briefs. That's fine. I usually take copious notes, so that's fine too. But in this case, it was kind of an education, again, on all the cases there are in arbitration about breaching the trust that an employer has to be able to have in an employee. There are so many things employees do that are just critical. Cops and teachers and correctional officers and probably many of the people that are under your supervision as far as HR situations. So that is a very important issue in arbitration. And if you're in management, that's a good issue to get up front, right at the way, to just be adamant on how important this this matter is, and have testimony from higher ups on how that breached the trust they reasonably expect to have with this employee. Okay. Now, for assuming now you've gone through, you've made your presentation, and you've proved that there was misconduct, that some rule or regulation or the collective bargaining agreement or something was violated, probably in just cause cases, we spend a third of our time anyway on figuring out what the remedy. And I don't mean what the monetary remedy is, because most of the time in the last few years, if I make a decision that there was not just cause and back pay might be implicated, I always offer to leave it to the parties. So it saves time and money on arbitration, and usually by that time, it's something the employer and the employer, the employer and the union rep, they can work out. So although more than several times, I have not awarded back pay at all, because even though the employer didn't prove what the person did would really justify a remedy of dismissal, there was obviously misconduct involved, and I didn't award back pay. And I've never caught any flack for that yet, but that's an option that you have. But I don't know how many of you have progressive discipline policies. Do any of you? Yeah, but I mean, most employers do have some kind of progressive discipline. So the question is always then, Well, how does that fit into the remedy? Well, I mean, it depends on what the progressive discipline policy says. For example, if it says, just let's say for the easy one is if you're tardy. If you're tardy 5 times, you get a suspension for 1 day. And 10 times you get a suspension for 5 days, and over 10 times. Right? Then you have a question of, well, it was only 1 minute each time. And, for comparables, and this guy had an hour for each time and that. But that's an example of a progressive discipline policy. If the contract said that, that's probably what the arbitrator is going to follow. But for discharge cases, excuse me, I feel like Marco Rubio taking my water sip here. But for misconduct that is subject to discipline, to a long-term suspension or a discharge, it's really pretty hard to find comparables, a comparable situation that is going to be persuasive with an arbitrator. Because to be persuasive, the factual situation has to be pretty similar. And in my experience, having gone through reams, I can think of one case involving a professor, and the union guy lawyer did such a good job. I mean, he presented all these cases, but I couldn't find any of them that I thought were reasonably related to the factual situation that I was presented with. It was just very different. So I find that comparables, when you're coming to discharge, that's pretty hard. And I've had also, when management tried to present comparables, trying to say, well, this is the same here. And I mean, if it's the same, I certainly will use that as a very important part of determining what the remedy is. But if you use comparables, they have to be pretty close to the factual situation you've got. So progressive discipline policy is important when you're trying to figure out a remedy that's reasonably related to the misconduct. The second thing, sometimes just cause has a limitation on what you can do, the actual just cause provision or the contract in that way. For example, the one I gave you that said that, I think it's the AFSCME contract that says the arbitrator cannot reduce the penalty, right? It's just that clear, they cannot reduce the penalty. Well, then you can't reduce it. It's just an up or downwind situation. And there are grievance procedure limitations usually. Usually, if I look in the grievance procedure in arbitration, there'll be something about just pay. There'll be something about the arbitrator can give an appropriate remedy subject to certain limitations. So I don't want to get into specifics because it depends on your contract, which you would be familiar with at the time, but be sure the arbitrator is familiar with that. And then finally, just generally on the remedy, past practice for similar violations. Well, that is similar to comparables. I guess that's basically what I'm talking about. Like, what have you done in the past? I had a case recently where a law enforcement case where the progressive discipline policy said something like, if you do this one time, I'm trying to think, it was a misconduct case, obviously a misconduct case about a law enforcement officer that was caught lying and had been caught lying a couple of times, which is a breach of trust issue for the city manager for sure. But they were trying to compare things that just they were not exactly comparable, but they were pretty close. Now, luckily for me, the violation, the lying, was such a blatant lie, and then when given the chance to correct it, the person didn't do it. That made it clear what I could do with the case. But it was hard to go back 20 years for these two employees, the employees that are trying to give comparables to. And one did something that was just like a misunderstanding when they first were a cop. But it was number one. And then they were trying to use it as comparable for the one that I was dealing with, which was lying pretty seriously each time. So an arbitrator is going to take all that into consideration within the bounds that they're allowed to. Okay. Now, this is my last chart, the last chart. And in it, there's a site. I thought you were all going to have these, but you don't have these little, but you're going to get these PowerPoints, right? Okay. Well, in there is a site. It's El-Khoury and Al-Khoury, how arbitration works. When I first started doing arbitrations, I was over at the library reading CCH and B&A and all these cases, you know, to try to, and I'm telling you, this is like the Bible. This is an excellent source. If you ever pick me for an arbitrator, you're going to see some citations from this, and I just don't see that you need to roam a lot farther than learning what's in this. This edition is 2003, I think, yeah, and there's an update to it. And I learned this from arbitrators, some of my buddies who are pretty well known, that said this is basically where you can find, has a lot of case citations. Are any of you familiar with El-Khoury and Al-Khoury, how arbitration works? Yeah, Jim is. I'm telling you, you should have it in your library. And if you have a labor problem, check to see what these guys say. I think it's a lady and a man. I don't know who El-Khoury and Al-Khoury are. I just know they first wrote it years ago, and it came out of conferences of labor and employment law. It may have been through the, I don't know, some national organization, but in these publications. And then they eventually started getting updates to it. And it has pretty much everything you need to know, to me, about labor and employment arbitrations that will go to an arbitrator through contracts like you have. Okay. So these are the things that I look at. I basically go to here. Sometimes there'll be things outside of this list, but you're looking for mitigating circumstances. That generally means ones that help the employee, and aggravating factors, which mean that help the employer. For example, nature of the offense, I am pointing at it, that is something that, if it's very serious, definitely is going to support what the employer is trying to do. And I try to go through these factors that are applicable in the arbitration award to show how I've weighed them. Like, for example, the length of service. If you've got a 25-year employee, I had a case recently. This lady was already at the end of drop. Okay, it was the last year before she got what was alleged to be a disciplinary transfer. Anyway, however it turned out, you don't need to know. But the thing was, that weighed heavily on my mind, that this lady had been to school, she was working with these disabled kids. Her past work record was no blemishes at all. And I'm trying to figure out, why are they trying to do, what has she done that would force her, and she was totally upset about it, and, and had all excellent, the highest, why would they be doing this? Well, I did kind of figure out why, and there really was kind of a reason, because she refused to get some training that the new principal thought was appropriate, and he could do that, and she was bucking him. So that was kind of what the issue is. But that length of service and past performance, those are very important. On the other hand, I'm telling you a few of the recent ones because that's in my mind. When the cases I have with the cops, they had a bad disciplinary record already. And so that didn't help them at all. That didn't mitigate the penalty. That would not mitigate the penalty at all. It would only was an aggravating factor and would help the employer. Warnings and knowledge of the rules. Usually with state government, everything's written down somewhere, except like do not murder someone, but it's all written down there. And lax enforcement, that's an issue. You know, if you don't enforce it, whatever the conduct is, that is, I mean, you don't enforce like a progressive discipline policy is how I've had it come up. That you say like a one offense, this, two offenses, this, but they didn't do it with these people, now they're doing it with him. That's a problem. That's a problem. The arbitrator's going to probably err, I would probably err on the side of, if you did it with 10 people and this is the 11th one, you're not doing it. On the other hand, if you've got a contract violation, and the contract says certain things, this is not allowed, and there's been lax enforcement, that doesn't mean at all that you can't pick somebody out to enforce it on. Just like speeding, if you get caught going 60 and a 45 or something like that, even though a lot of other people didn't, you know, they can get you. But on the other hand, if you're not enforcing like leave provisions, you know, like you're allowing 1 to 5 minutes to be not late, and all of a sudden somebody comes in and you start enforcing it, the arbitration decision might just kind of act as a warning that in the future they're going to be doing that. I've had a couple of Weingarten cases, you know, when employees, you call them in for discipline, you don't have to tell them, you don't have to read them their rights, it's not a criminal proceeding, but if they ask to have union representation there with them, you have to allow it. And you either have to allow it or not go ahead with the proceeding, one or the other. So if an employee isn't granted their Weingarten rights, the penalty would be mitigated to the extent that you would probably require the employer at a minimum to go back and do it again. That's a difficult thing when that's a violation of what is the appropriate remedy anyway. Okay, I think I'll stop there.